Now to our other top story, new laws will impact how you purchase and carry firearms in the new year.
We are paying for these weapons of war on our streets with the blood of our children.
The law, also known as SB 2, bans people from carrying guns in 26 places.
For removing weapons of war from the streets of America, we're actually telling them to repeal the Second Amendment.
People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year.
Background and legal battle. In the heart of sunny California, where palm trees sway and the ocean whispers its secrets, a legal tempest is brewing. The protagonist of our story? None other than Senate Bill 2, a brainchild of Governor Gavin Newsom that, in September, sauntered onto the legislative stage with the intention of reining in the Wild West spirit of gun ownership. Its most audacious provision? A sweeping ban on carrying firearms in certain public hotspots. Suddenly, playgrounds, stadiums, and museums became off-limits for gun-toting aficionados. But just when the script seemed to be heading towards a predictable climax, cue the unexpected twist. December rolled in, and the spotlight shifted to U.S. District Judge Cormac Carney. With a bang of his judicial gavel, he threw a spanner in the works, blocking Senate Bill 2. Why? Judge Carney argued that the law was doing a constitutional conga, trampling over the sacred Second Amendment. In his courtroom soliloquy, he didn't mince words, deeming the ban sweeping and repugnant. It was akin to challenging the Constitution to a duel, armed with nothing more than a water gun.
Now to our other top story, new laws will impact how you purchase and carry firearms in the new year.
Is it the most robust, far-reaching gun law in the history of the world? It is not.
The appeals court that was asked to step in and allow the regulations to continue agreed with the district court judge.
Members of Congress are also trying to answer what the Attorney General just called the most difficult question in a democracy.
The law, also known as SB 2, bans people from carrying guns in 26 places.
Yet, just as the audience braced for a fade to black, a new player entered the scene, the Ninth Circuit Court of Appeals. Charging in like the cavalry at high noon, they lifted Judge Carney's blockade temporarily. Picture them as the referees uttering, "Let the game begin, but we've got our eyes on the players." Suddenly, Senate Bill 2 took center stage, waltzing into action on January 1, 2024. The law was now in the limelight, and the legal water cooler became the epicenter of discussions. Was this a legal tango or a constitutional fandango? As the curtain rose on a new year, California surprised everyone. Surprise, we've got a new law in town. Yet the drama lingered on. The legal showdown continued as the Ninth Circuit Court of Appeals delved into the nitty-gritty of whether Senate Bill 2 was the hero or the villain in California's gun control saga. In this wild world of legal battles, it's a head-turner. Stay tuned, folks, because in the showdown between gun control and constitutional rights, the plot twists keep on coming. It's like binge-watching your favorite legal drama, but with more guns, more controversy, and California taking the lead in this gripping saga. So, here we stand, caught in the crossfire of a coastal breeze and a legal maelstrom, witnessing the unfolding saga of Senate Bill 2. Will it be remembered as the bold reformer or the constitutional maverick? Only time and the unfolding acts of this dramatic tale will tell. Provisions of Senate Bill 2. In the intricate tapestry of California's legislative landscape, Senate Bill 2 emerges as a pivotal player, wielding transformative changes in the realm of gun ownership. Among its nuanced provisions, the bill introduces a significant shift in the age requirement for obtaining a gun license. Previously a threshold crossed at 18, the minimum age is now elevated to 21, prompting contemplation on the intersection of age, maturity, and the responsibility associated with firearm ownership. In tandem with this age adjustment, Senate Bill 2 delves into the realm of gun safety, recognizing the need for a more informed and educated cohort of gun owners. The bill mandates increased requirements for gun safety training before individuals can secure a new license. This provision underscores the idea that responsible gun ownership extends beyond age considerations, emphasizing the importance of equipping individuals with the knowledge and skills necessary for the safe handling of firearms. However, the crown jewel of Senate Bill 2 lies in its delineation of specific public places where carrying firearms is prohibited. With a meticulous hand, the bill identifies 26 categories of such locations, including but not limited to playgrounds, stadiums, and museums. This list transforms these spaces into gun-free zones, sparking debates about the delicate balance between individual rights and public safety. Advocates argue that such restrictions contribute to a safer communal environment, while critics question the necessity of limiting gun rights in certain public arenas. The elevation of the minimum age requirement serves as a nod to the evolving societal perspectives on when individuals are deemed mature enough to responsibly wield the power associated with firearm ownership. It embodies a recognition that the decision to own and carry a gun necessitates a level of maturity and responsibility that may not be fully realized in the late teens. Simultaneously, the emphasis on gun safety training reflects a conscientious effort to bridge the gap between the constitutional right to bear arms and the imperative of ensuring that such rights are exercised judiciously. By mandating comprehensive training, the bill seeks to cultivate a cohort of gun owners who are not only well-versed in the technicalities of firearm use, but also attuned to the ethical and safety considerations inherent in such ownership. As Senate Bill 2 unfurls its provisions, it redefines the contours of gun ownership in California, addressing not only the legal aspects, but also the social and ethical dimensions of wielding firearms. The delineation of specific public spaces where carrying firearms is prescribed amplifies the ongoing discourse on balancing individual rights with communal safety, injecting a nuanced complexity into the dialogue surrounding the Second Amendment in the 21st century. Challenges from gun rights advocates. Now let's see where the gun rights advocates are drawing their battle lines. Enter the California Rifle and Pistol Association, striding into the arena with a staunch belief in the Second Amendment. These aren't just individuals, it's a coalition, a fellowship of those who see the right to bear arms as a cornerstone of personal liberty. For them, SB 2 isn't just a piece of legislation, it's a threat to the very essence of what they hold dear. It's like they're standing at the gates, ready to defend the fortress of their gun rights against what they perceive as overreach. In the heart of this legal showdown, the lawsuit details unfold like chapters in an intense thriller. Legal eagles from the gun rights camp aren't holding back. They're dissecting the specific provisions that put restrictions on carrying guns in places like playgrounds and stadiums. It's not just about slapping a lawsuit on the table. It's about scrutinizing every line, every clause, in defense of what they argue is a fundamental right. The arguments against SB 2 echo in the courtroom like the ricochet of gunfire. At the core is the claim that the law might be doing more harm than good. Gun rights advocates argue that by restricting the rights of law-abiding citizens to defend themselves in public, SB 2 is creating a situation where the good guys might be left defenseless. It's a classic showdown of perspectives, the right to personal defense versus the collective need for public safety.
We are paying for these weapons of war on our streets with the blood of our children.
Maybe now they've just priced you out of the market because you can't afford to pay those fees to get a permit.
For removing weapons of war from the streets of America, we're actually telling them to repeal the Second Amendment.
They are obsessed with attacking law-abiding Americans' Second Amendment liberties,
including public parks and playgrounds, churches, banks, and zoos.
It's not just about saying no to SB 2. It's about questioning the very essence of its existence. These advocates are wondering if the law is a necessary measure or just a case of gun control gone wild. It's a debate that goes beyond legal jargon. It's a fundamental disagreement on the role of the state in regulating firearms. For them, SB 2 isn't just a piece of paper. It's a symbol of the ongoing struggle between individual liberties and the broader notion of communal safety. In this saga, gun rights advocates are painting themselves as the defenders of a tradition deeply rooted in the fabric of American history. They're invoking the spirit of the Second Amendment, arguing that any attempt to curtail the right to bear arms is a step on a slippery slope towards the erosion of personal freedoms. It's a narrative of freedom fighters standing against what they see as the encroachment of a state that might be overstepping its bounds. As the legal dust settles, or perhaps stirs up even more, one thing becomes clear. California's gun control saga is far from reaching a resolution. The battle lines are drawn, the arguments are set, and the clash of ideologies reverberates not only in courtrooms, but in the broader conversations about the delicate balance between personal liberties and the pursuit of public safety. So, grab your popcorn, because this ain't just a legal drama, it's a tale of principles, rights, and the ongoing quest for the elusive equilibrium between freedom and order. Response from state officials. In the swirling vortex of California's gun control saga, the response from state officials is akin to the calm in the eye of the storm. Governor Gavin Newsom, a central figure in this legislative drama, wasted no time in expressing his support for the appeals court's decision, praising the move as a victory for common-sense gun laws. In the aftermath of the legal roller coaster that Senate Bill 2 found itself on, Newsom's stance is a beacon signaling the state's commitment to reshaping its firearm regulations. Newsom's words echo through the corridors of California's power centers, emphasizing the need for laws that align with what he deems as common sense in the realm of gun control. His support for SB 2 and the court's decision paints a picture of a leader unwavering in his dedication to reshaping the landscape of firearm ownership in the state. But the spotlight doesn't only shine on the governor. Enter State Senator Anthony Portantino, the architect behind SB 2. In the aftermath of the legal tussle, Portantino steps into the scene with cautious optimism. He expresses hope that the law he championed will withstand the legal challenges thrown its way. For Portantino, SB 2 isn't just a set of rules, it's a vision of a safer California, where gun ownership comes with added layers of responsibility and scrutiny. The senator's cautious optimism is proof of the uphill battle that gun control legislation often faces. It's an acknowledgement that even with a legal victory, the journey is far from over. Portantino, like a chess player surveying the board after a strategic move, is thinking ahead, anticipating the next moves from opponents of SB 2. As the legal drama unfolds, California Attorney General Rob Bonta steps into the fray, defending SB 2 with a firm stance. In a resolute statement, Bonta asserts that limiting guns in sensitive public places is a crucial step toward enhancing community safety. His words align with the core argument of SB 2, that certain environments, such as playgrounds and stadiums, should be free from the presence of firearms. Bonta's defense of the law isn't just a legal maneuver, it's a declaration of the state's commitment to a vision where public spaces are shielded from the potential dangers associated with widespread gun carrying. It's a narrative that pits the right to bear arms against the collective right to live free from the constant specter of gun-related threats.
Saturday, a federal appeals court put a temporary hold on the district's judge, ruling
that they have taken away our right to have reasonable restrictions. We can have restrictions on speech.
So right now you have to do an 8-hour course, and on the first, it actually is going to double the course to 16 hours, and then renewals are 4 hours.
That's not a right of government. That's a right that each of us has as Americans.
People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year.
In the grand narrative of California's gun control saga, the responses from state officials paint a complex picture. Newsom, Portantino, and Bonta stand at the helm, steering the ship through turbulent legal waters. The governor's endorsement signals a broader commitment to reshaping gun laws. Portantino's optimism reflects the determination to see SB 2 through its challenges, and Bonta's defense underscores the belief in the law's potential to enhance public safety. As the echoes of legal battles and policy debates reverberate through the state, one thing becomes clear. The response from these state officials is not just a reaction to a court ruling, it's a strategic move in a much larger chess game that continues to unfold on the grand stage of California's legislative arena. The saga continues, and as the script evolves, the responses from these officials will shape the narrative of gun control in the Golden State. National context and similar laws. In the expansive theater of gun control legislation, California's Senate Bill 2 doesn't exist in isolation. It's a player in a national drama shaped by legal precedents and the evolving landscape of firearm regulations. To understand its significance, we must cast our gaze beyond state borders, considering the echoes of the U.S. Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin, which acts as a silent orchestrator in the background. The U.S. Court of Appeals for the Seventh Circuit, based in Chicago, upheld that ban, signaling a judicial acceptance of stricter firearm regulations. These responses, akin to California's SB 2, showcase how states are navigating the post-Bruin landscape, attempting to craft laws that align with constitutional rights while addressing public safety concerns. The impact of the Supreme Court's decision reverberates not only in legal chambers, but also in the hearts of policymakers across the country. It's a catalyst for reevaluating and modifying firearms regulations, prompting a nationwide conversation on the delicate balance between individual freedoms and the broader responsibility to protect public spaces from potential harm. California, with its stringent gun control laws, finds itself at the forefront of this national dialogue. SB 2, born in the aftermath of Bruin, reflects the state's commitment to reassessing its firearm regulations. As legal battles unfold and states respond to the evolving national context, the saga of gun control legislation becomes a kaleidoscope of diverse approaches, each influenced by the nuanced interplay of constitutional rights, judicial decisions, and the imperative to ensure public safety. In this grand tapestry, California's SB 2 emerges not just as a state law, but as a part of a broader narrative, a chapter in the ongoing story of how America grapples with the intricate dance between the right to bear arms and the collective responsibility to foster a society where public spaces remain safe and secure. The legal drama unfolds, and each state, including California, becomes a protagonist in this ever-evolving saga of gun control in the United States. Addressing the epidemic. As the United States bid farewell to 2023, a year marred by an alarming 655 mass slayings, a somber reality hung in the air, more instances of gun violence than days on the calendar. In response to this disheartening trend, several states, including California, Illinois, and Colorado, ushered in the new year with a resolve to tackle the epidemic through the implementation of stringent gun safety laws. California, a state that has often been at the forefront of progressive legislation, stepped into 2024 with a robust plan to address the rising tide of gun violence. Governor Gavin Newsom, a Democrat, signed a law prohibiting the concealed carry of guns in 26 public places, ranging from parks and playgrounds to churches and zoos. This move, seen as a proactive measure, intends to create safer environments in spaces where the public gathers. However, the path to implementing this law was not without hurdles. A federal court initially suspended the injunction issued by a judge who deemed the law in violation of citizens' Second Amendment rights. The legal tussle reflects the ongoing struggle between the need for public safety and the staunch defense of individual gun rights.
This is a violation of that federal law. The federal judge that initially ruled in this agreed, saying it's up to Congress.
They are coming for your guns. They're listing them out in this extensive legislation.
And they're saying, they have the authority to do that. The gun rights groups that are suing
about the number of issues that they have with people who have permits, and it's none or very, very, very few.
In most public places, even with the concealed carry permit is now in effect, even as the case makes its way through the courts.
The legal challenges and opposition underscore the deeply ingrained debate surrounding gun rights and restrictions, where each legislative move is met with a countermove in the complex chess game of gun control. The U.S., grappling with a prolonged history of gun violence, witnessed over 18,800 gun demises, 36,200 gun injuries, and more than 24,100 suicides in 2023, as reported by the Gun Violence Archive. The staggering statistics, coupled with a resurgence of advocacy efforts following the tragic events in Lewiston, Maine, highlight the urgent need for comprehensive firearm safety measures. In the face of this grim reality, the contrast between the U.S. approach and that of other nations is stark. While countries like Norway and New Zealand swiftly implemented bans on attack weapons after single mass slayings, the U.S. continues to navigate a political landscape marked by inertia and reluctance to adopt large-scale reforms. As the new gun safety laws take effect, their success and impact will be closely observed, providing a glimpse into whether these measures can shift the trajectory of a nation grappling with the devastating consequences of gun violence. Illinois' attack weapon registration deadline. As the curtains of 2023 drew close, the United States witnessed a staggering tally of more mass slayings than days in the year, a grim reality that prompted several states, including California, Illinois, and Colorado, to usher in new gun safety laws on January 1, 2024. In the heart of this nationwide dialogue on firearms, Illinois faced a critical deadline, adding another layer of complexity to the ongoing debates surrounding gun control. At the forefront of Illinois' gun control measures is a statewide ban on attack weapons and high-capacity mags, signed into law by Governor J.B. Pritzker on January 10, 2023. As the clock struck midnight on the cusp of the new year, it marked the culmination of a grace period granted to those who owned attack weapons before the law's enactment, a period dedicated to registering these firearms to comply with the new regulations. The controversial measure not only enforces a ban on the future purchase of attack weapons and high-capacity mags, but intricately navigates the nuanced terrain of pre-existing firearm ownership. Monday's deadline acted as a pivotal moment for gun owners in the state to register their weapons, providing insight into the compliance and potential challenges surrounding the enforcement of such laws.
These laws come into effect in the aftermath of mass shootings that have rocked the state and nation.
For a case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past.
Of domestic abuse, you shouldn't have a gun. If you're on social media threatening the lives of people, you shouldn't have a gun.
He told me that the new laws go too far. He said they aren't even needed in the first place.
Their legal analysis is poor, their conclusions are misguided, their outcomes are dangerous.
Gun control activist Rachel Jacoby, who played a pivotal role in advocating for the Protect Illinois Communities Act, expressed her concerns about the impact of gun violence on affected individuals. Her perspective, shaped by the tragic mass slaying in Highland Park in 2022, underscores the urgency of addressing the multifaceted trauma resulting from such incidents. Jacoby's hope, echoed by many activists, is that future generations won't bear the same burdens and fears related to gun violence. The intricate dance between constitutional rights, public safety, and mental health remains a central challenge in the broader context of gun control. While laws like Illinois' attack weapon ban aim to mitigate the risk of mass slayings and enhance public safety, the ongoing dialogue grapples with striking the right balance between individual freedoms and collective security. As the nation reflects on the toll of over 18,800 demises, 36,200 gun injuries, and more than 24,100 self-hurt in 2023, Illinois stands as a microcosm of the broader struggle to find effective and fair solutions to the complex issue of gun control. The evolving landscape of firearm regulations coupled with the diverse perspectives of stakeholders, underscores the ongoing national debate and the challenges inherent in navigating the intersection of rights, responsibilities, and safety. That's all for this video, folks. We'll see you next time.